From Boyle Heights in Los Angeles, California, Libros, Schmibros Lending Library presents the Latinidad Beyond Borders podcast. Latinidad encompasses the diverse experiences of people who live in Latin America, as well as people of Latin American descent who live in the United States. This podcast explores culture, society, and politics across the Americas through the lens of Latinidad. Welcome to another episode of Latinidad Beyond Borders. I'm your host, Alberto Sahagún. Today's topic is immigration rights. My guest today is Jennifer Chacón. She is Bruce Tyson Mitchell Professor of Law at Stanford University. She co-authored the law textbook, Immigration Law and Social Justice, and she also co-authored Legal Phantoms, Executive Action, and the Haunting Failure of Immigration Law, published in 2024. Welcome to the show, Jennifer.
Thank you so much. I'm happy to be here.
Thanks for taking the time. So, Donald Trump ran for president, promising mass deportation, and he won. Now it's been over a year since he's been in office, and he's attempted this mass deportation. Billions of dollars have gone towards immigration enforcement, detention centers. There are heavily armed, masked agents who have gone across the country, claiming to be looking for dangerous, undocumented immigrants. But what we've seen is that many citizens and immigrants who are lawfully here, or undocumented people who have contributed to the country, are being targeted. And in the past, we've seen immigration removal, where people are targeted. There's a court order to remove them. But now we have these federal agents, ICE and other federal agents, roaming cities, streets, going to public places, businesses, approaching people in their car. And a lot of people are fearful, and Latinos in particular feel targeted. So people have been challenging this through protest, but also through the court system. So over the past year, there's been a number of litigation that's going through the court system. Some has gone before the Supreme Court or will go before the Supreme Court. So talk about the issue related to racial profiling and how groups have tried to fight that in the courts. And also, right, the courts are made up of individuals who have different interpretations of the law and different political leanings. So what have we seen over the last year?
Right. So as you mentioned, we've seen a shift to enforcement through raids, whether that's at workplaces or just even in public spaces. And that is a real shift in immigration enforcement tactics in the interior. We haven't seen this sort of raid activity really since, in some ways, the 1970s and 80s. We saw a lot of it. We saw some workplace raids under various administrations since that time, but these sort of street sweeps that we're seeing are new in recent memory, and the scale of them, I think, is quite new because we've seen Congress substantially expand the amount of resources available for immigration enforcement, and a lot of that enforcement is being performed in the interior of the country, which is quite unusual. And so we have seen allegations of racial profiling in these interior enforcement efforts, and some of those challenges have been working their way through the courts. The most high-profile example is the litigation that was out of Los Angeles, the Vasquez Perdomo case. And this was a challenge brought by the ACLU and others to some of the workplace and street sweeps that we saw in the Southern California area, in the Central District of California. And it was pretty clear, and in fact, I think agents were clear themselves that stops were being made on the basis of what an individual looked like, so their racial appearance, the language they were speaking, the job they were doing, and where they were. So someone working in a car wash in Los Angeles in certain neighborhoods who also appeared to be Latino would be targeted for further investigation about their immigration status. And so there were challenges to this as impermissible uses of race and racial profiling, and we saw that go to the courts. We saw a federal district court judge in the Central District of California issue a temporary restraining order telling ICE stop making these stops if the only factors that you have considered are race, language spoken, Spanish or English spoken with an accent, job, and location, right? If all you're doing is relying on those four things, the judge said this is impermissible racial profiling and not a permissible way to conduct an investigative stop. And so the district court judge issued a temporary restraining order. We saw the practice really decline in that part of California in response to the judge's orders. The government appealed to the Ninth Circuit Court of Appeals. The Ninth Circuit largely upheld the district court judge's temporary restraining order, and we saw continued kind of holds on this widespread ICE and CBP practice. And then the government appealed to the Supreme Court, and the Supreme Court on the shadow docket stayed the temporary restraining order, meaning they allowed these policing practices to go back into effect pending further litigation. We don't know what the court's reasoning was. We got a dissent from three justices. Justice Sotomayor issued a dissent that was joined by the two other liberal justices. And then we had a concurrence from Justice Kavanaugh giving his explanation about why he thought the temporary restraining order needed to be stayed. The rest of the court didn't write. This is in sort of emergency posture, so it is not fully litigated. Litigation challenges are actually ongoing. But what it did mean was, as you know, for now, ICE can continue making stops on this, on kind of without the constraints that the lower courts had placed. And Justice Kavanaugh's reasoning really drew very heavily on a 1975 case from the United States Supreme Court, a case called Birgnoni Ponce. And in that case, we had an automobile stop of a car by a Border Patrol agent. The stop was the agent said the stop was motivated because the individuals in the vehicle appeared Mexican. So it was very clearly based solely on race. And the court in that case said, well, you can't make a stop based solely on race, but you can take Mexican appearance, is the language of the court. You can take quote unquote Mexican appearance into account in determining whether to make an investigative stop for potential immigration violations. And so they said, you can't use race alone, but you can use race in conjunction with other factors like what are they wearing, what kind of vehicle, how close are you to the border? And so Justice Kavanaugh sort of resuscitated this 50-year-old precedent and said, you can take quote unquote Mexican appearance or Latino appearance, Hispanic appearance into account when you make these stops, or at least for now, citing to Brignoni Ponce. And that was really kind of where most of the reasoning rested. And so as a consequence, the lower court's restraining order is no longer in effect, but the litigation is ongoing. And I think the ongoing litigation is important for two reasons, at least. One is the case in this, the question in this case was really around investigative stops. And investigative stops are supposed to be brief encounters whereby you can question someone and then either the questioning will give rise to probable cause that justifies longer detentions, or suspicion will be diffused and the individual should be allowed to be free to leave. And one of the things that the litigation is highlighting is the fact that that is not what is happening in a lot of these encounters. So individuals are being not only stopped on the basis of race and other factors, but they are also being held sometimes for hours, sometimes taken to detention, sometimes moved from one location to another. And you cannot justify a brief investigative stop merely on reasonable suspicion of an immigration violation. At that point, you need probable cause. In many cases, you may need a warrant. And it's pretty clear that that's not what's happening on the ground. So there are challenges to whether, even if you're allowed to take race into account in making a brief investigative stop, the agents in these cases are taking that too far. So that's one problem. And I think the second problem is whether we should still be allowing the use of racial appearance in the making of immigration investigative stops at all. The Brignoni Ponce case is from 1975. The demographics of the country were very different in 1975. The percentage of the population overall that was Latino was much smaller. The demographics of the undocumented population was very different in 1975 when it was predominantly Mexican. It is still the case that the majority of undocumented people in the United States are Mexican and Central American, but it is also the case that over a third of them are Asian, white. And so the idea that you can just decide someone's undocumented by looking at them makes less and less sense. And the other thing that has become true in the US courts is that the courts in other contexts have been quite clear that reliance on race for any reason, including benign reasons like affirmative action, is not permissible. And so if you can't take race into account when deciding whether somebody should be admitted to an elite private university, it seems odd that you would be able to take race into account when deciding when an armed agent of the state can stop you, detain you, and question you about your citizenship. And so there's a real asymmetry that's developed in the Fourth Amendment jurisprudence when compared to the equal protection jurisprudence. And I think that is a question that courts need to dig into.
Yes, but of course we have the Supreme Court, and it seems like they've indicated the direction they would rule as this different litigation comes in. But of course, things can be we're not certain. Some judges could be swayed over time, perhaps.
Yeah, I mean, to that point, one thing that was interesting was you might recall that the Trump administration deployed the National Guard to Illinois. And there was litigation over whether he had exceeded his authority in deploying National Guard troops to Illinois. That case did not involve questions of racial profiling. It was purely a question of executive power to deploy the Guard. Justice Kavanaugh has a footnote in his opinion in that case where he says, of course you can't rely on race in making investigative stops. So that case was decided several months after his concurrence in Brignoni Ponce, in a case that really didn't deal with the issue of racial profiling in investigative stops. But that footnote to me suggested that the criticism, correct in my view, the criticism that he was hearing from the public about the concurrence in Vasquez Perdomo, about what some people have taken to calling Kavanaugh stops, had some effect on the way that he was thinking about the role that race was playing in immigration investigation. So, of course, we don't know. And I am never going to be optimistic about outcomes in the Supreme Court, but I do think it's interesting to see the way that he was responding in some sense to the public pressure or the public criticism that was brought to bear over his opinion in the earlier case.
Yes, that's very interesting.
Yeah,
And
yeah,
there's a lot of litigation that's challenging different aspects of immigration enforcement. So there's also issues of once someone is detained who is not a citizen, whether their due process has been fully exercised. There's
mhm,
also issues related to the detention centers and the conditions people
yes,
who are detained in are living in. And we know that people have died in detention centers.
yes.
So yeah, can you talk about some of those challenges in the courts that are going through the court system?
Sure. So immigration detention has been a longstanding problem in the United States. It is, as a legal matter, it's formally labeled civil detention, civil administrative detention. The court, over a century ago, authorized the use of immigration detention as an adjunct to the removal process. So if someone is in the process of being removed, they can be detained administratively. What that means as a legal matter is that some of the kind of thick protections that apply to individuals in cases involving criminal detention don't actually apply or have not been read to apply in the same way with regard to civil immigration detention. So, for example, in the criminal context, you can't have indefinite detention. You have limits on how long people can be detained. In the immigration detention context, people are often detained indefinitely. They don't know what their release date will be. It all turns on how long their proceedings take. And so you don't have those kinds of temporal guardrails on that detention. And you also have the Supreme Court signing off on Congress being able to categorically decide that broad groups of people can be subject to immigration detention during the pendency of their removal proceedings. So without determining whether a particular individual poses a flight risk or poses a threat to the community, they can be detained if Congress sort of says categorically this group of people can be detained. So, for example, individuals with criminal convictions that Congress has labeled aggravated felonies, they can be categorically detained if they're put in removal proceedings without determining whether, as an individual, they actually pose a flight risk or a danger. So this is very different from what we see in the criminal context, where at least nominally you have to be able to show a reason that you're holding someone before they've actually been convicted of a crime. So there are people in detention who have either fully completed their criminal sentences and should be free unless they're a danger or flight risk. You have people in immigration detention who have no contact with the criminal legal system at all, but they're being detained because they are in a civil administrative removal system. So lots of people in detention. And one of the things that this administration has done that is distinct is it has reinterpreted a provision of law that Congress added to the statute in 1996 that authorized the detention of individuals who were arriving into the United States. And it said if you're arriving in the United States, you are subject to mandatory detention. That's what Congress had said. So that means you get detained throughout the pendency of your removal proceeding, whether or not you pose a flight risk or whether or not you pose a danger. So this is a categorical detention statute that applies to arriving individuals. The administration is currently applying that to not people who are coming to the border right now, but to anybody who's in the country who has never been inspected. So anybody who entered without inspection at any point, 10 years ago, 20 years ago, 30 years ago, the administration is taking the position that these individuals are arriving and that therefore they're subject to mandatory detention under Section 235 of the Immigration and Nationality Act. This is the first time any administration has ever interpreted the statute this way. There's pretty clear evidence Congress didn't interpret the statute this way. Just this year, Congress passed something called the Laken-Riley Act, where it expanded the use of immigration detention, including immigration detention for certain individuals who had entered without inspection. They would not have needed to add these provisions in Laken-Riley if those people were already covered by Section 235. So this administration is aggressively reinterpreting who is covered by that provision. And what that means is longtime residents of the United States, people who are deeply embedded in community, are being put in immigration detention now, because they can under this reinterpreted vision of Section 235. They're subject to mandatory detention, so no individualized hearings. Nobody's asking whether they themselves pose a flight risk or a danger to the community. And in most of these cases, the vast, vast majority, they don't. Because if they did, they'd be subject to detention under other provisions anyway. So the people who are really being taught by this provision are people who should not be in detention. And they're being detained. And so we're seeing the numbers of people who are in detention really swelling. We're seeing the expenditures on immigration detention rising rapidly. We're seeing the standing up of new detention facilities, the East Montana facility in El Paso, the provision in Florida that the administration sort of ghoulishly labeled Alligator Alcatraz, right? These new immigration detention facilities that are holding a bunch of people who really shouldn't be in immigration detention at all. And then I would say, we need to ask whether anybody should really be in immigration detention at all. Conditions, as you noted, are bad. There were 6 deaths in detention in the month of January alone. So extraordinary rising in the rates of medical problems in immigration detention facilities, of deaths in immigration detention, real rise in the number of children and families in immigration detention, the same sort of thing that sparked outrage in previous administrations before and lawsuits. And then we're hearing reports of conditions that are truly substandard in immigration detention. So food that's inedible, sanitation problems. And so these are by and large individuals who should never be detained. They're not only being detained, but they're being detained under conditions that are truly deplorable and inhumane. And it's clear that the administration is attempting to use detention to force people not to stand on their rights and to instead, quote unquote, voluntarily leave the country rather than continue to try to survive conditions that are very difficult to survive.
Yes. And another radical step by this administration is challenging birthright citizenship. Uh, I thought this was settled law. The 14th Amendment said that if you're born in US soil, you're a US citizen, doesn't matter the status of your parents. But this is going before the Supreme Court soon. So, how is this administration challenging birthright citizenship, and what do you think we can expect once it gets to the Supreme Court?
Yeah, so this is a challenge that I feel like should never have taken this long to resolve. It is pretty straightforward as a matter of law that the 14th Amendment provides citizenship to individuals who are born subject to the jurisdiction of the United States. And this administration is certainly subjecting undocumented people to its jurisdiction. So that's certainly happening. And the historiography is quite clear. The framers of the 14th Amendment were responding to the racialized exclusion of populations from US citizenship by enacting the 14th Amendment to ensure that all people who were born subject to the jurisdiction of the United States would be given citizenship. And they were specifically answering the problem of a racialized citizenship regime that led to the Civil War and that ultimately generated the 14th Amendment response. So it is quite clear that this is the 14th Amendment was designed to solve a problem of racialized citizenship, and that the way that the Trump administration is attempting to redefine citizenship cuts directly against what the 14th Amendment is designed to achieve and what it says. So the text of the amendment is quite clear. So the legal scholarly consensus is firmly on the side of against the administration. There are always some legal scholars who find some evidence for any theory. But for the most part, the scholarly consensus is pretty clear. And you can see, even if you had doubts about the meaning of the birthright citizenship clause, the idea that the president, by executive order, could somehow alter the birthright citizenship regime is quite a novel idea. And so this is one case where, although I'm not the kind of person who espouses putting great hope and faith in the Supreme Court or any court, I think I would say that I'm pretty sure that the Supreme Court is going to rule against the administration in this case. And I think in part because, as the oral argument in the case revealed, if they didn't, the logistical problems that would flow from a ruling to the contrary would be tremendous, right? How do you then go about establishing who is a citizen? Does this mean the president has made this prospective, but does this mean that the president can retroactively change the rules of citizenship? How do people go about establishing their citizenship? You know, there are few people who are less documented than US citizens, really. Like, the idea of what it would take to prove citizenship in the absence of our clean, bright line birthright citizenship rule. The infrastructure and the administrative systems are not in place for that. And so I think, both because of the history of the 14th Amendment, the text of the 14th Amendment, and also because of the sort of administrative issues that a different ruling would have, I think this court, no matter how inclined they might be to support the president's policies in other realms, and no matter how resistant they might be to sort of the racial justice that is reaffirmed through the affirmation of the 14th Amendment, I think even this court is going to find that the administration's position here is not one that they're willing to swallow.
Yes, I hope so. Uh,
Me too.
thank you. Well, thank you so much for taking the time to come on.
Thank you.